Court of Florida is now in session. All who have cause to plead, draw near. Give attention, you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning, everyone. Welcome to the Florida Supreme Court. Before we begin, let me just announce that we have here from Florida State University 70 students from their summer undergraduate program, people who I believe are testing the grounds as to whether they want to go to law school or not. So if those in the program, would you please stand? Well, thank you for filling up the courtroom for us. Thank you. Welcome. I hope you enjoyed your day. Okay. That said, the first case on the docket today is Odom versus Rj Reynolds. Whenever you're ready.
Good morning, and may it please the court. I'm David Sales. I'm here with Daniel Hoffman. We represent the petitioner and the plaintiff in the trial court, Gwendolyn Odom.
You want to speak up a little?
Sorry, thank you. Thank you, Your Honor. This court requires great deference to the compensatory damage verdict awarded by a jury, and even greater deference once a trial judge denies a motion for remittiture. Lassiter holds that a defendant bears the burden of showing that a jury's verdict is excessive. Bould versus Touchette and other cases identify the nature of that burden. They require a showing that the verdict is unsupported by the evidence and reaches, using words of the decision, unreasonable, outrageous, or extravagant levels, or alternatively, a showing that the verdict is the product of passion and prejudice. Lassiter calls such verdicts ones that are inordinately large. And while this court has certainly recognized results in other cases as something to be considered, that consideration occupies a significantly less important place in the hierarchy of such factors. In fact, the court has recognized the risk inherent in making such comparisons because every case is different, and indeed, like this case, some are unique, using the words of the district court. In the food fare case, in fact, this court was more specific, noting that it had considered smaller verdicts in similar cases, and such verdicts might be persuasive if the court were fixing the damages in the first instance. The court said, however, quote, viewing them as an appellate court, the disproportion between the analogies and the case at bar is not sufficient to force us to conclude that the jury was motivated unduly by passion and prejudice. After all, that is the test. In this case, the district court and Reynolds placed nearly their entire focus on the results in 4 other appellate cases and 1 federal trial order that Reynolds has added to the mix in its briefing.
Well, let me ask you this.
Yes, Your Honor.
You said that it was not, this case is not the result of passion or, so what was the basis for the jury verdict?
Well, importantly, there were 2 parts to it, and one of the points we make in our brief is that the trial court was obviously heard, and the jury heard evidence about pre-death damages, which were an important part of our case. The district court and Reynolds in its briefing have focused almost exclusively on the issue of the loss of relationship, loss of consortium, loss of guidance and instruction, almost completely ignoring the nature of the damages that we proved between the date of the diagnosis and the date of death in 1993, a 2.5-year period where these women together experienced an extraordinary journey involving real pain and suffering during treatment, which was shared by the claimant in this case, the hope of remission, only to be followed by a recurrence of her lung cancer, which had spread throughout her body, leading, as we point out in the brief in the description of the facts, to very dramatic circumstances near the end where the claimant saw her mother develop a stroke before her eyes, which was precipitated by the cancer, because these are the kinds of diseases that devastate. They're different from what we typically see in a whole variety of wrongful death and personal injury litigation. And that is completely ignored by Reynolds, and it was completely ignored by the district court. But it's one of the reasons, yes, Your Honor.
But you said there were two aspects to it?
Yes, the other aspect, of course, is the loss of the relationship, which is the focus of the district court. And the district court's opinion essentially says that the type of relationship governs the damage award. And we take the position that the court obviously felt that something in excess of what it called multi-million, which, as we point out in the brief, can only mean what is suggested by those plain words, something more than $2 million, cannot be achieved lawfully in a case where the relationship is one between an adult child and a decedent. There was no basis for that other than, and we say that the root cause of that, the root reason for the decision in Reynolds' argument goes back to 2000 in the Suarez case, because that is the case where the third DCA, in fact, did say that $1 million was excessive for multiple adult children. But as we point out in the brief, the factual circumstances of that case were quite different. There, the girlfriend of the decedent had led to an alienation of the affection between the deceased parent and the children. Yet, if you look at the way this has come up, because from 1990, when this remedy was first available for adult children, until today, there were virtually no cases prior to Engle litigation other than those two cases, the Ahmed case, which approved $400,000 for surviving children, and the Suarez case. And what the district court has done is taken that relatively small number of cases, and they did the same thing, I would submit to Your Honors, in Putney. They've taken that relatively small sample of cases and said that as a result of them, there is no discretion for the trial court. And if you look at the opinion on page 6, they really say that in two places. They say it at the top, the first full paragraph, basically that no matter what the evidence shows, this class of claimants, an independent adult child and that of a deceased parent, that relationship can never justify a multi-million-dollar award. The court did say that it was applying the abuse of discretion standard, but if you look at the bottom of that same page, what they say is the relationship between an adult child living independent of the parent is simply not the type of relationship which can justify the magnitude of the plaintiff's award. Accordingly, based on the cases it cited, we hold that the trial court abused its discretion when it denied the motion for remittitor. We would ask the court the following. Where in this decision are the types of questions or answers that appellate courts are supposed to ask when they review a verdict for excessiveness? No discussion of passion and prejudice. No discussion of the jury's perspective, of the trial court's perspective, not even a passing reference to the trial court's order, which, as the defense points out, was drafted by plaintiff's counsel in the case. But I would point out to the court that it is not accurate to state that this trial judge only had 24 days, 24 hours of reflection before it entered the order denying the motion for remittitor. What happened was there was a hearing. The trial court said it wanted to review the authorities. Both sides were requested to submit dueling orders citing the same authorities that you've read in these briefs and appear in the trial court's order. And after a total of 4 days, which we submit is sufficient time for reflection on that handful of authorities and what the trial court already knew about the evidence in the case, that was more than sufficient for the trial court to decide that, yes, indeed, it rejected the position of Rj Reynolds, excuse me, that the verdict was the result of passion and prejudice.
I want to go back to
Yes, Your Honor.
the wrongful death statute, and it said that in 1990, before that, if an adult, it was 20, the ceiling was 25 years for an adult child, correct?
Yes.
Okay, and
You couldn't be a claimant if you were not 25.
couldn't be a claimant,
Right.
and there was a statement that I think you made in your brief that Rj Reynolds talked about, which is something about the philosophy of the wrongful death statute.
Right.
You mentioned pre-death pain and suffering, so we're clear. The wrongful death statute says the survivor or the personal representative on behalf of the decedent cannot claim pre-death pain and suffering for the decedent.
For the decedent, the
So
pain
it-
and suffering that is available.
So it's, the philosophy is, it is switched from the decedent to the surviving either spouse,
Right.
or if no, only in the case of no spouse, to the adult child.
That's exactly right. And the statute is actually quite clear on this. In fact, the court recently amended or approved and amended to the standard jury instructions that added the expression, which is the law, from the statute, that pain and suffering arises from the date of injury. And in this case, presumably that would be no later than the date of diagnosis for the decedent. And so, yes, we were entitled to recover, the plaintiff was entitled to recover all of the pain and suffering, her own, not that of the decedent. But one of the things that's interesting about this case, and, you know, when we're in these situations,
And let me go one other part, just about this
Yes, sir.
financial dependence. That is a separate element of damage.
Right.
It's not a prerequisite for an adult child to claim the non-economic damages.
That's exactly right, and I see that embedded in the cases that the district court relied on, going back a ways, you know, as an additional ground. Perhaps it was a throwaway ground, perhaps it was not. But the district court certainly mentions that. The Webb case, where we were counsel in the Webb case, the first DCA mentioned that as though it were important. And one of the two cases that they rely on heavily, either Suarez or Ahmed, also referenced the fact that there was no financial dependence. But the statute is very clear. There's a delineation between economic and non-economic damages recoverable not only by the estate, but also recoverable by individual survivors. And the only economic remedy recoverable by a survivor, of course, is for support and services. And that sort of segues into the concept in this case that when the district court said it's all about the relationship and whether you live with the decedent or not, I mean, the evidence in this case was that these women were not only extremely close in a unique relationship, according to the court, but that they were in contact virtually every day, and that during the intense period, what I would call the acute phase of pain and suffering in this case, the diagnosis to death period, they were together virtually constantly. And this woman, our client, was not only caring for her mother, was not only supporting her emotionally, she was working a full-time job and taking care of 2 children. In the midst of all that, she watched her mother, in her own words, basically waste away, looking much like a woman 20 years older than she was by the time, near the time that she had her stroke and died. So the district court did not consider any of those factors, and we think that that's important. I also want to urge the court to consider one of the arguments that we've made in this case, which has never drawn a response from the defendant. 2, actually. The first is, you know, we do this work and we are aware, of course, that in lung cancer cases, particularly in the Engel litigation, the verdicts have trended higher. And for the judges who are out there who are wondering why this is so, this is a case which it gives the reasons for that. Because it is somewhat unusual. Certainly there are other conditions besides lung cancer and emphysema which can lead to a prolonged course resulting in death. But the nature of cigarette-related injuries, diseases, they ravage the body. And in this particular litigation, the claimants are older in part because it takes decades to get COPD. It takes decades to get lung cancer. And by the time these people are sick, the adult children are the ones left, as I put it in the brief, carrying the standard of a wrongful death case. And that's one of the reasons why we disagree with the concept that you cannot compare one relationship under the wrongful death statute to another. Nobody's denigrating the spousal relationship. It's obviously incredibly important, and the verdicts in these cases involving spouses are large. But we take the position that because of the unique role that adult children play in this litigation, certainly when someone is suffering from the ravages of cancer or emphysema, that is appropriate. And we have no reason to provide an excuse for an award of this magnitude in this case. And the jury did its job. And that brings me to the last point I want to make before I save my rebuttal time. We have argued in the district court, and we have argued before this court, that there is no exact standard for the jury to measure these things. That's a standard jury instruction, which was given in this case at 4285 and 86 of the record. They have an obligation to fix the pain and suffering in these cases to the best of their ability. And what we do is we come in, as lawyers are empowered to do, and suggest a figure. And in this case, my co-counsel suggested a figure of $5 million. After hearing that suggestion, Reynolds was very clear to the jury that it was placing its trust in the jury, and this is a quote, "We simply leave it to your good judgment and common sense. We leave that question to you." It was Reynolds' right to make that strategic choice. The problem is, the record in this in many cases show that it's not sincere. As the remitted practice in this litigation shows, time and time again, Reynolds is leaving the matter of damages.
Wasn't there something, whether she should be made a very wealthy person?
Right, but that there was no context to that
No,
at
I'm
all.
saying,
Right.
but that's all they said.
That's all they said. And what's happening in these cases is that Reynolds is leaving the matter of damages not to the jury, but looking to the trial courts when the verdicts are adverse to rescue them in post-trial motion practice. But importantly, and this is really an important point, they are seeking appellate review of these awards, but they are doing it in a very selective way. For example, this court heard the Murata case. Murata was a case where there was no appellate review sought of $2 million awards for adult children. Another case decided by the first DCA is Mrazek. Those are two that come to mind. No appellate review sought of denials of motions for remittitor in those cases. And by doing that, because there is so much volume of this litigation, Reynolds is able to take the position that the Suarez case from 2000 involving alienated children sets the ceiling for damages in a wrongful death case involving one class of claimant.
Mr. Sells, you're into your rebuttal time. You're welcome to continue, but you got 5 minutes and 8 seconds left.
I just want to say in regard to that, if the district court's decision stands, it will confirm that Reynolds is making the correct strategic choice, that in fact the courts most respectfully do not mean what they say about how we test a jury.
Let me ask one
Yes, Your Honor.
question. It's, I mean, the jurisprudence of this state's been going on for years and years and years. And now we've apparently hit a class of cases that the facts, as in all cases, impact what a jury does. We sat here and we have meticulously gone through in prior cases. It's part of the record in those cases, all the evidence that's involved in these smoking cases. How much of that kind of factual information, that type of testimony came before this jury? And what would be your response to that? Because we know, the tobacco defendants, which they're entitled to do, have raised certain defenses with regard to these things. But just how much?
This case, I would say, from memory, that was an issue in the district court, whether or not we had proven the conduct that was sufficient to support the verdicts for the intentional tort claims. And this case, from memory, was very similar to the conduct evidence that Your Honor is talking about, if that's what you're talking about. And if the question from Your Honor is that's what's driving the verdicts, my response to that is twofold. First, the jury is told not to be swayed by passion and prejudice. And the court's decisions, including Carter versus Brown and Williamson, require us to presume, unless there's something that shows otherwise, that the jury follows the instructions. But
Well, you've been doing this a long time. I mean, you're aware, as I am, that there's a lot of talky talk that goes into the law.
Right.
And as we're trying to analyze and what's going on with verdicts and what is the proper role of courts
Right.
with regard to verdicts. And that's what we're talking about this morning.
Yes, sir.
And that's what seems to ruminate throughout these kinds of cases. When you tell a jury and give them the kinds of facts that are in some of the smoking cases, I can see that there are folks that are outraged by it. And then that becomes, is that something becomes an unstated feature of the trial that we're dealing with in virtually all of them? Because, I mean, when it comes in with regard to hidden facts and things like this, or even suggestions, it causes a citizen to react.
I would say a couple of things about that. First of all, the plaintiffs don't win all of the cases.
Well, I'm well aware of that.
Secondly, in many cases where the plaintiff wins, the damages are quite low by comparison. In other cases where the plaintiff wins, they are not only failed to prevail on the intentional tort claims, but there is very high comparative fault that's attributed to the smoker. And so my perspective on that is that, yes, it is certainly possible, and that's the role of the trial judge, to make sure that the case was tried in a way where nobody steps out of bounds, where the jury hears the facts that they're supposed to hear, and that they don't do the kinds of things that would lead to a finding of passion and prejudice. It should be remarkable to the court, because we're here, yes, I understand the institutional concerns that you're talking about, but we're here in this case. And Reynolds did not actually raise in its briefing the issues that you are discussing.
Oh, no, I understand. I'm speaking to not conduct of counsel that creates the outrage,
Right.
but just the nature of the case
And that-
produces outrage. And a lawyer could come in and try a Casper Milquetoast case and really say not much of anything, and the facts shout out certain things.
I'm just about to run out of time. The last thing I want to say about it is, in this case, the jury's verdict reflects some dispassion. First of all, we were hit with 25% comparative fault, which is different from what we requested. Because the Shove case hadn't been decided yet, that had a real impact on the verdict in terms of the judgment. It led to a reduction, of a 25% reduction in the compensatory verdict. And in fact, on the verdict form, the jury was told, which is one of the reasons we didn't seek review of it, was told that there would be a reduction. So the jury knew about that. It knew it was going to result in damages that went down. And in addition, even though it awarded a little bit more in the compensatory phase, it awarded significantly less, millions less, than we requested in the punitive phase. And now I've used up all my
Well, I'm
rebuttal.
sure that our kind Chief Justice recognizes that I've manipulated this argument at the end, and he will certainly grant you sufficient time.
Thank you very much, Rob.
I will give you 2 minutes in light of the fact that we helped you use your time for rebuttal. Hang on for a second. In my zeal to identify the students here today, I neglected to mention that Justice Poston is unable to participate in today's argument. However, he will be participating in the decision of all cases heard today. Sorry, go ahead.
Good afternoon. Good morning, Your Honors. Excuse me. Thank you very much. Jeffrey Buchholz for Rj Reynolds. I'd like to start with jurisdiction, Your Honors, because I think that's where the court should start. And I really don't think the court has jurisdiction here because the 4th District said that it was applying abuse of discretion review. It said that repeatedly. And
Ask you this: how could you right line cap on actual situation standard? I mean, right line cap on damages holds as a matter of law, then it means the trial judge has no discretion, right?
Thank you for asking that, Your Honor. I want to address that directly. We don't think, 2 things. First, we don't think that when you read the opinion as a whole, including all of the stuff that comes before the paragraph that Your Honor is asking about, and the stuff that comes after it, we don't think the opinion actually contains a holding that there's any kind of hard and fast numerical cap. And we think that's the best way to read the opinion as a whole. All the opinion held is that this award, which is $6 million, which is a lot more than $2 million, which is the multi-million number that plaintiff interprets the opinion as setting a cap at, all the opinion holds is that this award, $6 million, on these facts, is so clearly excessive as for it to have been an abuse of discretion to deny remittitor. There's no conflict as to that rule of law, that standard of review, or that result. But, sorry.
Analyzes other cases and comes to this conclusion no matter how. And then that seems to be the basis for the reversal. I don't see any other factual discussion of that conclusion, like a holding.
Well, Your Honor, as I said before, there's 2 things I wanted to say. The first is that I don't agree that that's a holding in the opinion. But second, maybe more importantly, if this court reads the opinion as containing a holding, you could think of it as 2 holdings. One holding, the narrower holding, the one necessary to the decision, is this award, $6 million, on these facts is grossly excessive. The second holding, not necessary to the decision, is multi-million-dollar award would be the cap.
What fact was analyzed other than the fact that this?
Well, that she hadn't lived with the years and that she was married and had 2 children of her own and was not dependent on the parent in a way that could justify a larger award. But I don't want to quibble with Your Honor's reading of the opinion. If this court thinks that the opinion holds that there's a hard numerical cap, we disagree with that. We don't think there's a basis to say there's a hard numerical cap. We didn't argue in the trial court or in the 4th District that there should be a hard numerical cap. We don't think the 4th District created one, but if this court thinks the 4th District did, then we think it would be fine for this court.
In the other cases, statutory factors and discussed where the prejudice, where the improper influence came in, what facts led to the verdict that were not the kind of things that should have been considered. Maybe I'm missing it, but I don't see that kind of analysis. I don't see the factors discussed other than saying here they are.
Well, I think what the 4th District starts out the section of the opinion by laying out all of the factors, right? It's true, Your Honor, that the court doesn't come back and say, after discussing the awards in other cases and the evidence in this case, tie that explicitly to factor D or factor E in the statute. I think in substance that's what the court was holding, is that the statute says you have to look at whether the evidence supports the award, whether the award could be the result of reasonable jurors, whether it could be logically adduced, et cetera. That's all in substance what the 4th District was holding. But again, I want to be clear about this. We don't think that there's a basis for a hard numerical cap. And if this court wants to say that if you read the opinion as creating a hard numerical cap, and that's the holding that conflicts with other decisions, then this court can say, so read, the opinion conflicts and quash that holding.
So
we don't think it.
You would concede that if the opinion does hold that there's a hard numerical cap, that jurisdiction exists.
Yes, on that assumption, right, which again, we don't agree that that's the right way to read the opinion as a whole. But if this court thinks that the opinion actually contains a holding, because again, it's important for whether this court has jurisdiction, whether the language about a cap is holding or dictum. I mean, as this court said in Changoli, even where the district court in that case had said that there was a conflict.
What other basis for reversal is explained in the decision? That's not the holding. What's the...
No, let me try to be clearer, Your Honor. The basis for the holding is that the trial court abused its discretion. The trial court's order never mentions the standard from this court's decision in Lassiter or Bould about whether the award clearly exceeds the maximum limit of a reasonable range. That's the standard for excessiveness. The trial court never mentions that. The trial court never acknowledges that there's never been an affirmed award to an adult child, anything approaching the award here. And the trial court never really engages in that required analysis. So the 4th District holding, if you read the opinion narrowly, is holding only what it had to hold in order to decide what it decided. It held the trial court abused its discretion, which we think is correct, because when you have to look...
But in a holding, don't we have to look at the rationale. It's not just the result. There's a path of reasoning here, and there's steps in that path of reasoning that lead to the particular result. And I'm struggling with what the court says about their interpretation of Webb and Putney, and what is established by Webb and Putney is not a holding.
Again, Your Honor, I really don't want to quibble about this. If the court thinks, the way that I think it is, that the paragraph that starts read together, the paragraph that contains the language that we're talking about, is not necessary to the decision. The decision, this is not a $2.5 million award, where whether there's a $2 million cap...
Why would we not think that it's the rationale for the decision?
It is part of the rationale for the decision. And so if this court thinks that, then as I said before, we don't think that there's a legal basis for the 4th District to create a hard numerical cap. So we think in that case, if that's the court's reading of the opinion, then the court does have jurisdiction on that reading, because there is then a holding, two holdings. There's one holding, the broader one that we're talking about, that's not necessary to the decision. It's part of the rationale, but not strictly necessary, because the award here is $6 million, not close to $2 million. This court can quash that part of the decision, and then we think the court should leave the rest of the decision intact, because this is not an award that's close to the line.
See, there's where we get back to the line. Now, are you now getting into the merits? Or do you want to say anything else about jurisdiction?
Well, on jurisdiction, I guess the way that when I say there are two holdings, I think it's important to distinguish this. If this award here had been slightly over $2 million, and the court said what it said about a multi-million award being, suggesting that could be a cap, then you would know that that was essential to the decision, because the award was only slightly over $2 million, so the only basis to say...
Okay, so let's go now. You say that there's been a cap established by case law that in wrongful death cases involving smoking-related injuries, where Mr. Sales points out that unlike automobile accident or something where the decedent dies immediately, you've got years of pre-death pain and suffering, that the maximum cap, no matter how close the child is to the parent, and this Rj Reynolds never takes issue with the nature of this relationship, the maximum is $2 million. Is that what Rj Reynolds is saying this court should hold, even though
No, Your Honor.
Rj Reynolds never even suggested a number to the jury?
No, Your Honor. We don't think that there's a hard numerical cap of $2 million or any other number. We don't think that.
So
We've
let's
never
go
argued
back
that.
to this one. What is wrong in this case, $6 million reduced by 25%, $4 million, for the decedent was 58 at the time of her death, the survivor was 42, they had a unique relationship, unlike, as Mr. Sales says, Suarez, where so often adult children are alienated from their parents. This couldn't have been a closer bond. This could not be a more textbook example of the love that a mother and daughter had for one another. So you're saying $6 million reduced by $24 million is too much for this loss, considering the 3 years of pain and suffering that she went through as she watched her mother die?
Yes, Your Honor. That's our position.
So what
The
is
statute
it? So it's $3 million? Is that the cap?
The statute requires looking at whether the evidence here can support the award. This court, since 1935 in Florida Dairies, has said one of the things that you have to do is to look at the general philosophy and trend of awards in similar cases. Adult children cases,
Let me ask you about the similar case. Politically, I also have that an adult child cannot factually the same mental anguish that a spouse could, factually. I mean, take a plaintiff, how do you find them? And this is a very personal, very independent thing. Actually, how can we say as a matter of law that this child could not possibly suffer the same mental anguish that a similar situation?
because I think, Your Honor, since 1935, this court has said you have to look at similar cases. There is a difference. We're not saying that there's a hard and fast numerical bound on one category of cases versus another category of cases, but at the same time, it is quite relevant that this plaintiff was a 42-year-old independent adult who had not lived with her parent for 13 years, who had 2 children and a husband of her own. And that person, just by the nature of those undisputed facts, suffers a different kind of loss, a different kind of injury from a minor child who loses a parent
But don't you
from a
think,
spouse.
here's the issue about the wrongful death statute, and I think you took issue with what they said. This adult child over 25 can only claim these kind of damages, even though she suffered as much as she did, if there was no surviving spouse. So it seems to me that the tobacco companies can wait for the spouse of the decedent to pass, and then make this argument that the damages are capped. I have always seen the philosophy of the wrongful death statute as taking and shifting where the losses are going to be able to be claimed. So this decedent's survivors could not claim the decedent's pain and suffering, correct?
Right.
So would you agree that for the 3 years that this survivor took care of her mother, took her to all the appointments, and watched her waste away, that is itself a substantial award that should be acknowledged? Let's take that death, pain,
Right,
and
Your Honor.
suffering.
That's the way the jury was instructed here. We don't dispute that. We don't
Well, so
dispute
what is
that.
that? What is that? Those 3 years of watching a loved one die of lung cancer. What is the? Is that a $2 million loss? Is that a $5 million loss? Is that a $10 million loss?
Your Honor, the facts that you're asking about do not distinguish this case from Putney, where the Fourth District says in Putney that the daughter who got a $5 million reward, which the court in Putney...
But we're here because there seems to be a trend in the various appellate courts to put some bright line cap on it. I'm asking you, based on what's been argued here and what the facts are, what is the significance of a lengthy period of pre-injury, pre-death pain and suffering?
The significance, Your Honor, is that that means that the evidence here with those facts could support a somewhat larger award than a case involving an otherwise similarly situated adult child without the pre-death suffering period. But
Okay,
again,
so
the methodology...
now we go to the spouse. If this had been a spouse, and maybe their relationship was okay but not great, would that support, if the spouse was still alive, the same kind of pain and suffering, loss of companionship? Would the Rj Reynolds be saying that that could only be a $2 million award?
Well, it
if
would
there was
depend
a
on-
surviving spouse?
It would depend on the nature of the relationship. Your Honor's question said if the relationship between the spouses wasn't great, so if the relationship between the spouses wasn't great, then perhaps the award wouldn't be able to be very high. Again, the methodology under the statute and under this court's case law going back from before I was born is that you have to look at the general philosophy and trend of similar cases. So you have to figure out, what does similar cases mean? What cases are similar? Cases involving minor children are, just as a matter of common sense, different from cases involving independent adult children. Cases involving spouses are different. I'm not saying that there's a hard and fast range in one category versus another, but as a matter of common sense, they're different. And so when this court engages in the methodology that it's required to engage in, and looks at awards in similar cases for adult children, what this court finds is there's never been an award for an adult child affirmed more than $400,000, 600-something thousand in today's dollars. And so we're not saying that's a cap. We're not saying that's a ceiling. Mr. Sales said that by not appealing awards in other cases that we try to create a ceiling. We've never argued that there's a ceiling in that kind of a mathematical way. We're not suggesting here that the court couldn't reasonably, or the jury couldn't reasonably say that the award, that the injury suffered here would support an award higher than the award, even adjusted for inflation, from Ahmad from a long time ago.
Well,
but this is an order of magnitude
So
more.
the jury, okay, so what you're really saying is that the remitted or statute should have as its major factor, because the judge is going to know, the jury is going to know, awards in similar cases. That should be the major factor that the trial judge looks at in deciding whether the award is excessive or not.
Among other factors, but that's a factor that this court, even before this remitted or statute was enacted, has said that is important. This court in Florida Dairies, in Pendervis, in Lofton, and in various other cases over the decades has reiterated that part of the analysis has to be comparing the award to similar cases. And now that we have a statute that explicitly says you have to evaluate whether the evidence supports this award, whether this award could be rendered by reasonable jurors, whether it could be logically adduced, whether it's in light of the injury suffered, and you look at other cases involving similar injuries suffered and what awards were affirmed there to get a sense of what reasonable range there might be. Again, the standard under Lester and Bould is, did the award here exceed the maximum limit of a reasonable range? We're not suggesting that there's a cap from any prior case individually. We're not suggesting that any prior case sets a mathematical limit. This court said that the test of the general philosophy and trend is whether the award bears a reasonable relation to the general philosophy and trend. So you could say the prior case is distinguishable, therefore the award here could be somewhat higher. This isn't somewhat higher. This is an order of magnitude higher than any prior affirmed award. An order of magnitude higher.
But
If
it
this
looks like
award
what's
had been...
it looks like what's I'm sorry, go ahead.
Factor in the reality that in this particular case, when plaintiffs went to the jury and explained why they believe that a $5 million verdict was perfectly appropriate on these facts, that was the jury's decision. Defense counsel said, well, if you think so on these facts, that's fine. I just have a concern about them coming and looking at the doesn't bear a reasonable relationship to the facts in this case. I mean, that's the jury. I mean, why shouldn't you? You're asking us to judge a jury verdict when you did nothing, or plaintiff's counsel, defense counsel did nothing below to explain to the jury why, on these facts, that amount of money.
Two responses. First, Justice Lawson, the cases that say, I believe in dictum, that it could be a relevant factor whether the defendant suggests a number, all involve awards within the range suggested by the plaintiff. This is an award $1 million higher than what the plaintiff suggested. And the plaintiff didn't say, by the way, to the jury, we suggest $5 million, you can go above that, you can go below that, it's up to you. The plaintiff said, I submit the award should be $5 million.
Is it not?
I'm sorry, Your Honor?
The law in Florida is that a jury can award more
We're not suggesting
than
that
a
it's...
plaintiff may request during closing argument.
Yes, we're not suggesting that it's error per se that the award exceeded the request by the plaintiff. We're not suggesting that. We've never suggested that. But simply in response to Justice Lawson's question, the cases that have thought it was relevant that the defendant didn't suggest the number have emphasized that the award was within the range argued by the plaintiff. This award was higher than the range argued by the plaintiff. But more fundamentally, I don't think there's any legal basis to suggest that the defendant has an obligation to suggest a number. The defendant here was defending as to liability. The defendant is not required by any principle of law that I can imagine to suggest a damages number on pain of somehow forfeiting the review for excessiveness that the statute requires, that precedent requires, by not suggesting a damages number. But to whatever extent the court might think that that's even a factor to go into the analysis, and we don't think it is, here the award was higher than what plaintiff requested. And again, fundamentally, this is not a close case. This is not an award that's a little bit higher than awards in similar cases. It's not a situation where you could say, well, you know, there's a basis to extend what the awards had been in similar cases
But you
because of the
keep on saying
facts here.
similar cases. I look back at these cases, and this, the first case, whether it was Suarez, and you had a situation where the children were alienated. The facts of this case, if you had to take a poster case for what an adult child would have a relationship with their parent, this would be it. They were 16 years apart. Every factor in there points to a substantial verdict for her pain and suffering, loss of companionship. So when you say other cases, I read all these other cases. I don't think there's anything similar to this case.
Well, Your Honor, I would disagree as to Webb, where I think there was an extraordinarily close relationship between the adult child and the parent in Webb. In Putney, there's less specificity in the opinion, but it does say in Putney that the daughter, the named plaintiff in Putney, was devastated, the same word used here, took the parent to appointments, killed her on the inside to see her at the appointment. So I don't think it's accurate to say this case is so different from the other ones. But anyway, to the extent that this case is different, it means that the award here could be justifiably, in terms of remitted or statute, somewhat higher than awards in similar cases. It doesn't mean the award can be an order of magnitude higher than any prior award affirmed by any court of this state for any adult child under any set of facts. That is grossly excessive under the remitted or statute and under this court's precedent.
Did the
I apologize, Your
defendant
Honor.
at least argue and assert that the number presented or the arguments presented by this individual's counsel were inappropriately high?
In the trial court, you mean, Your Honor?
No, to the jury.
Yeah, I'm sorry, that's what I meant. Yes, in front of the jury in closing argument, it is true, as petitioner pointed out, that our counsel did say something to the effect of, I don't have the precise words in front of me, we leave the damages number to your good judgment if you get that far. But before that, counsel said, you need to decide whether the evidence that you've heard really justifies the amount of money that you heard the plaintiff ask for. And
that's not challenging that amount is too high in so many words. See, we're coming. This is something that is to me is abhorrent to the law, and that is in every case. I mean, people go to their death because they haven't raised something, and now here we come, and we don't have to tell a jury what the outside parameters are, and our jury instructions don't do that. Yet I can come back in later and go to a single judge and have that judge change it when I have never even offered any guidance to a jury
Your Honor, with respect, the statute requires the courts to engage in what the legislator decided was in the best interest of the people.
I understand that. I'm asking
And
about
there's
the practical effect of that. I know what the statutes say.
Right, but there's no legal basis to say that a defendant who's contesting liability forfeits the right that the statute provides to have the court review the award for excessive.
I'm not saying forfeits the right to it. I'm saying is that you have to factor that in with regard to looking at the amounts awarded.
Well, we don't think there's a legal basis to even factor it in, but if there's a legal basis to factor it in, at the margins, it still doesn't justify this award here.
Now, you said it just, and I know you're way out of your time, but you said Webb was just like this case. The decedent in Webb, and it was distinguished in the trial court's order, lived to the age of 78. This decedent was 58. 20 years is a pretty, and then the surviving daughter was already 54 when the decedent died. So, and there were some other things. So I don't, when you say, do you think 20 years is not is it insignificant that there's a 20-year difference in life expectancy?
Your Honor, I don't think I said, or I certainly didn't mean to say that Webb is exactly like this case in the respect. The question that you asked me earlier is about the nature of the closeness of the relationship. In Webb, the relationship was very close on the very unusual facts of that case than this case. That's what I meant to say before. But to respond to Your Honor's question, no, we're not suggesting that that's irrelevant. We're not suggesting, again, that the award in Webb on remand after the remittitor somehow sets a numerical cap for what the award could be here. It's not that kind of a one-to-one mathematical analysis, but it nonetheless is relevant that Webb is a highly similar case, although not identical for the reason Your Honor points out.
Okay,
And thank you, Your Honor. I appreciate it.
Way over your time. Thank you for your argument. Mr. Sells?
Thank you, Your Honor.
Let's shoot for 2 minutes.
Yes, Your Honor. A couple of things. It wasn't, Justice Lewis, that they're just saying, come in after the fact and change it. They have made it clear, and it's in part because of this court's decision in Waste Management versus Mora, that the remittitor practice in the trial courts in this litigation is a little bit of a shell game, to be totally candid, because they know what we won't accept. They know that they're only going to request a remittitor that we won't accept. And as has happened in the subsequent case in Webb 2, I don't have the citation in my head, the trial court remitted the damages to the amount that the plaintiff requested and said that's that. And then they went up and they said, and they got the first district to agree, that they get a new trial because they don't like it. So this idea that there's really, that the remittitor practice is being used for the purpose for which it's intended, which is to allow the trial court to be the gatekeeper, and remembering that it's obliged to set the damage award at the highest level under this court's authority that can be supported by the evidence. So the idea that they're not asking for a cap is really not correct. And in fact, if you take a look at their reply brief in the district court, this is page 1, it was filed January 8th of 2016. There, they argued that Putney was a cap of $5 million. And because we got 6, that binding precedent in which this court held that $5 million wrongful death award to an adult child was excessive. They argued there was a cap there. And contrary to what counsel suggests, he referenced only one of the survivors. And this responds to Justice Pariente's thoughts on this. This is from Putney, the same case. One of Margot's sons testified how he visited his mother as often as he could once he heard of her lung cancer, but it was difficult to do because he had his own family. Were the other siblings in a better position in terms of damages? Yes. But the point is that they have been angling for there to be a cap from the beginning, and that's exactly what they did in this case, and they got what they wanted in the district court, because Justice Lawson, it's not only that the court said what it said in the language that everybody keeps quoting in this case, but at the end of page 6, the court says, the relationship between an adult child living independent of their parent is simply not the type of relationship which can justify the magnitude of the plaintiff's compensatory damage award. Accordingly, the trial court abused its discretion when it denied the motion for remittitor. So yes, that is the holding of the case in addition to the one that you quoted, that according to the 4th DCA, if you get whatever, we could argue about what multi-million really means, I agree with that, but whatever it means, and common usage suggests 2 million, that's all right.
You would agree with Mr. Buchholz that the fact that
I don't agree. I don't agree. I don't agree that we don't claim that it's dispositive. And we urge the court to look at Judge Altenburn's comments in the Hawk case, which have been followed in cases in the second DCA and a number of federal cases that are cited in our brief. It's a factor to be considered. And the factor, the way it's explained in those cases is when the defendant comes to court after the fact, to quote Judge Posner, having gambled and lost, then it should be much more difficult for them to persuade an appellate court like this court that the damages awarded by the jury are unreasonable or extravagant or shock the conscience or whatever legal maximum is going to be applied to the particular circumstances of this case. And I know my time is now up as well, Your Honor. Thank you very much.
Thank you for your argument.